What is a continuation patent application? If you've ever done patent searches or you've looked at the face of a patent, you might have occasionally seen a statement that says this patent is a continuation of another patent, giving the serial number and the filing date and possibly the patent number if the patent is issued. So what does that mean? When you file a patent application, there are two primary components that make up that patent application. The components are the patent specification and the patent drawings. The third part of the patent application is the legalistic part of the patent application called the claims. The claims are what define your invention. The claims are the name of the game. If the patent office decides that your claims are allowable, then you'll be issued a patent on those claims. The patent that you'll get, patent number 1, would have the first claim set that you filed with the original application. So I'm calling that claim set number 1. Now, that said, it's possible that within your patent specification and drawings, which is generally referred to as your patent disclosure, you may have additional patentable subject matter that could be claimed in addition to claim set number 1. That's one possibility. The other possibility is that there may be a little bit different way to claim sort of the same subject matter that's a little bit different in claim set 1 that might give you a different layer of protection of your invention or your product. And so for that reason, before this patent issues, once you know that it's going to issue, you can file what's called a continuation patent application. The continuation patent application would utilize the exact same patent specification and the exact same patent drawings, but would have a different set of claims, claim set number 2. Then what would happen is you would go through the patent prosecution process again. It could be the same patent examiner that gets assigned to the application, or it could be a different patent examiner, and it also could be a different art unit. But when your patent application gets filed, depending on the technology that the claims are related to, the patent office will assign that patent application to what's called an art unit. That art unit is responsible for evaluating claims related to a certain technology area. That technology area will have examiners that look at patent application claims within that art unit only, and they decide if patents get granted in their art unit. If you file a second set of claims, depending on how closely those claims are related to the technology or to the subject matter claimed in the first patent, you will likely get assigned to the same art unit. However, there is a possibility that you could have a second set of claims that are related to a different art unit. That's less likely in a continuation patent, but it is a possibility. But in any case, the point is that the examiner that's assigned to the second set of claims will go through an examination procedure the same as the examiner did with the first set of claims to decide if those claims are allowable. If it turns out through prosecution, and you may have to also argue and make amendments during the prosecution, as with any patent application, it may turn out that you get the second claim set allowed. In that case, you would be granted a second patent, patent number 2, with claim set number 2. Before that patent issues, you could then file yet another continuation patent application with a third claim set. Now, all of these claim sets have to be sufficiently supported by the specification and the drawing. If you have enough patentable subject matter disclosed in the patent specification and the patent drawings, then you're able to file continuation patent applications to claim that subject matter with different claim sets. Of course, the claims have to be supported by the patent specification and drawings, just like in the first patent application. If the claims can be supported, you're entitled to file a patent application for those claims. In fact, if you have patentable subject matter in your disclosure that you didn't claim, you could be missing out on having patentable subject matter granted, because once this second patent were to issue, let's say, If you had patentable subject matter to warrant filing another continuation with a third claim set, but you failed to do so, or you decided not to do so, then that unclaimed subject matter in your patent specification and drawings becomes what's referred to as dedicated to the public. Dedicated to the public means now, if it's not claimed, anyone can use that because that technology, that disclosed technical information is part of the public domain and it's usable by anyone. Now, usually you're going to have claims that are going to cover what you consider the inventive subject matter. If you do that on your own as a pro se applicant, you're going to want to make sure that you craft claims covering what you believe to be, what you've analyzed and what you believe to be your patentable subject matter. For more information about how to do that invention analysis, take a look at my video linked here. If you're not filing the application pro se, then your patent attorney is going to be helping you to do that invention analysis to determine what the claim set should be. That said, if there's additional subject matter that could have been claimed that wasn't claimed in the application, you could be at risk of that subject matter becoming dedicated to the public, meaning you won't have rights to it, even though you've disclosed it in your specification and drawings because you failed to claim it in a patent application. So that is one danger to over-disclosing in a patent specification. You want to disclose enough information to enable the person of ordinary skill in the art, the hypothetical person of ordinary skill in the art, to be able to make and use your invention. If claim set 1 is what you consider to be the invention and you've disclosed enough information for someone to be able to make and use that, that is adequate disclosure to support the claims under 35 U.S.C. 112, which is the section of the law that requires adequate disclosure. If you could have done that with a 25-page disclosure, but you decided to disclose all these other aspects of your technology and you filed a disclosure with 150 pages and 35 pages of drawings, it's very possible that within that extensive disclosure, you had other potentially patentable subject matter. If you failed to claim that, and after claim set 1 gets allowed, you don't file any continuation applications, you may be losing out subject matter that you could have claimed. So this is something you should be very aware of when you're preparing your patent application in terms of what you're putting into it and what you're intending to claim, what the specification and drawings are intended to legally support with respect to the subject matter you intend to claim. Now, what's another reason? What's another reason strategically to file a continuation application? One strategic reason to file continuation patent applications is that when you first file the patent application and you get your first claim set allowed, you don't know exactly how your competitors are going to try to copy your product. So because you don't know that, it's a good thing to have another patent application pending, because what can happen is as your competitors start to copy your technology, you now have a patent application pending that you can amend, and you can amend the claims to read on or read upon your competitor's technology more closely. That's a strategic reason to have a continuation patent application pending, because it allows you to better target your competitors as you see how they're going to use your technology and their products, and you can tailor your claims to more directly target them as infringers of your technology. So to summarize, the purpose of continuation applications is twofold. One is to make sure that you've captured all of the patentable subject matter that might exist in your specification and drawings, that is within your invention disclosure documents. The second reason is the strategic reason of trying to target your competitors after your first patent was allowed, to see what your competitors are going to do in terms of using your technology and their products so that you can more directly target them for infringement.